Greetings, everyone. My name is Tabile Ndlazi, and I'm the project leader for this project for POPIA compliance training. I'm here to introduce our speaker for today, the instructor of the training, Dr. Tobin. Dr. Tobin has about 40 years of business and management experience in different industries, and he has published over 25 academic conference papers as well as journal articles. Dr. Tobin has spoken in South Africa and as well as international conferences, and has facilitated over 180 workshops in a number of fields, including the protection of personal information, IT governance and management, cyber security, in the past 25 years. He has about 5,000 delegates who have attended his protection of personal information training. He has also delivered workshops and courses in Botswana, Democratic Republic of Congo, Namibia, Germany, Ivory Coast, the Kingdom of Eswatini and Lesotho, Mauritius, Namibia, Nigeria, Tanzania, and Zambia, in addition to South Africa. Dr. Tobin was also a full-time academic at one of South Africa's leading business school in the past 25 years, the Gordon Institute of Business Science, GIBS, at the University of Pretoria from 1999 to 2011, during which time he delivered over 100 academic programs from junior management to senior executives, including lecturing for 12 consecutive years in the GIBS MBA program. Please help me welcome Dr. Tobin.
Thank you for that introduction, and it really is a pleasure to be here with you at the University of Fort Hare. It's not my first visit to East London, but it is my first visit to your East London campus. Thank you for those who are attending this session in person, and I see we have pretty well a full house this morning, and I know that we're busy recording this session so that others can share in this experience a little later. We're going to make this, hopefully, an engaging workshop because the topic is of interest and because you're going to be participating. There'll be an opportunity for you perhaps to discuss with your neighbor, and certainly from time to time during the workshop, I'm going to be posing questions which hopefully not only you as a live audience, but those who are going to be watching the recording later will have a chance to think through the implications of what the Protection of Personal Information Act means to you as individuals and to your institution as a whole. During that very kind introduction, it was mentioned that I have many years of experience in a number of fields. In particular, if I take you through the slide on the top left, I've been working in the field of IT governance, of which you could understand perhaps that the protection of personal information is almost a subset of a focus on the broader issue of how do we govern, how do we manage effective use of information and technology. Going back earlier in my career, I was also a certified and continue to be a certified project manager. And I think it's very important to understand that the success of any initiative, such as compliance with new legislation, which is the context for this morning's training, is something that really needs to be managed effectively, and so we've been deploying project management principles throughout the engagement, which myself and my team have been involved in since June last year. Depending on when you're watching this recording, we're currently in, and I'm losing track, are we still May? Are we June? We're into June, so we're very much a year on from the original initiative, but it I think gives you some idea of the depth of work that's required to investigate and then to implement the approach needed to guarantee that we're complying with the legislation. As was mentioned, I also have some background, and I think it's an important context for us this morning to understand that South Africa is absolutely not alone in terms of implementing legislation which gives protection to individuals as to what happens to their personal information. In particular, one of the big landmark activities around the world was when the European Union, and more technically the European Economic Area, which includes a number of countries that are not full members of the European Union, adopted the General Data Protection Regulation back in 2018, and that's when it came into full force. Now, you'll see on the slide here that the French word atelier is showing. That means that I have passed the certification from the French regulator for the General Data Protection Regulation. It's spelt a little differently because of the acronym in French, but that means I'm happily able to bring to the party, as was mentioned, I've worked in Ivory Coast and Mauritius on international privacy projects. I've been a certified information privacy manager since 2018. I think it's important that we recognize the global context for what we're trying to achieve here in South Africa, and it's right that we should bring that experience to the party. The last thing is that I am a proud graduate of the University of Pretoria. And apart from saying go Tuckies, which is perhaps understandable, I'd like to just explain that my work there was in the field of information science, more narrowly in the field of knowledge management, and in particular, I did research into stories and storytelling and how organizations can share knowledge through the use of stories and storytelling. And I think that's relevant to this morning, because no doubt we're all going to share a few stories that concern the protection of personal information. So that was by way of introduction to myself, just to fill out a little background. And here's why I believe that we are here this morning. These are the objectives for the session. Number one, to educate you about the Protection of Personal Information Act, or POPI, or POPIA, as I know the regulator prefers us to say. There's a difference, isn't there, between education and training. Academic institutions tend to deal in knowledge development, knowledge creation, knowledge transfer, and that's very much what the spirit is of what we're doing here today. It's about education. The training aspect can only really happen once we get into the practical application and develop skills. So today we're restricted because of the nature of the work that we're doing here in a presentation environment to really only talking about education. The training is going to be very much when we get back into our day-to-day work environment, but I'm going to explore with you some ideas of how we can develop some of the personal skills that are going to help to contribute to making sure that not only we as individuals, but the team as a whole and the institution at an institutional level, University of Fort Hare, can become and maintain compliance with the POPIA Act. So first thing is to educate. The second thing is to stimulate some discussion, not only in the room here, not only with those people who are going to be viewing this as a recording later, but also more widely. This legislation is very important in terms of South African society as a whole. It applies to all of us as individuals. In the terminology used in the legislation, we're called data subjects. It's information about us that this legislation concerns. And that applies to us in the various roles that we play in society. Looking around the room here, I can see we probably have a number of mothers and fathers, legal guardians perhaps, parents of children, where there are great concerns today about how can I protect the privacy of not only information about myself, but also about my dependents or children. All of us, I think, feel the pressure that comes from using technology to help us to better manage information and the potential abuse that that technology may be put to. And therefore, it's important, I think, that if we stimulate some discussion with our stakeholders, and here in particular, in the context of the university, our major stakeholders, of course, is our student body, but it includes the people who are members of the community within the university, staff members, whether they be full-time, part-time, whether they're contract, work experience, or interns. There's a wide variety of team members, if you like, where I think it's good that we should stimulate some discussion with those people who are not here in the room today, but others who will, no doubt, over time, be following the discussions that we have here this morning. So I'd like you to stimulate some discussion, both within the workplace and more broadly in the community. Thirdly, I'd like to motivate you to take the POPIA Act seriously. There's, of course, a limit as to how much we can cover in the brief time that we have available today, but I'm delighted to say that the compliance team, and thank you for that introduction this morning from the team leader, to say that the compliance team have access to a wide range of resources which will help us all to better understand the POPIA Act and, as you'll see, some other related legislation. And therefore, the door is open for us to explore more after this workshop to get a better grasp, to better understand some of the practical implications of where we're going from here. I'm also going to make a slight apology as we initiate this program, because as we have a recording happen, it's not so easy for me to go around the room and become fully familiar with who you are as delegates. That would have been relatively time-consuming and not so easy for the cameras and microphones to pick up. So I'm going to apologize that if I don't engage with all of you directly now, but it would help if we're going to engage later during the presentation, that whenever you have a comment or a question or you have a suggestion or I ask you to engage, if you briefly state your name and which part of the university community you're from, that will help to give some context to the engagement. Are you happy? Can we do that? Yes. That's excellent. So the agenda is really in 3 or 4 main parts. The last part being a Q&A session, question and answers, which may be covered during the course of the session itself, but there will be time at the end of the session should there be anything lingering that you'd like to raise at the end. I'm happy to take questions as we go along. You can do that by a show of hands or make a note of something that you'd like to discuss later. As I mentioned, we will be having a break, which will give you an opportunity maybe to raise something with me during the break, which we can address during the second half of the session. So the first main topic, and this is an obligation that we have based on the legislation, that an organization, and we'll go through the roles and responsibilities of an organization like University of Fort Hare, is required in terms of the POPIA Act to create awareness of the legislation amongst your stakeholders. In particular, anybody who is employed by the university, in terms of the law, is seen to be acting as the university itself. In other words, you are the agent, if you like, you are the individuals who are representing the university and therefore need to understand what the implications are in terms of playing that role, and that means, of course, we need to have at least a high-level understanding of what the legislation's about. This will not be a legal presentation, not least because my background, as you will have heard, is not that I am an attorney, I'm not a lawyer, I'm not legally qualified, but that's not why my clients have asked me, as you have, to assist in understanding the implications of the legislation. There's, of course, an important role which can be played for people who have a legal background interpreting the law. What we're really trying to do here today and in your day-to-day activities is help you to understand the operational implications and how this fits in, this legislation and your response to it, as part of good governance. There's a clear commitment, not only from your institution, but other public universities and other bodies around the country, that we must make sure that we are responsible stakeholders, which includes understanding and complying with relevant legislation. So it's an important requirement that we need to address to create awareness, and I'll do that by taking you through, at a relatively high level, an understanding of what the POPIA Act is, but more important is, so what do we do about that? And the second part of the presentation, therefore, will look at the impacts and actions, and this is something that we've been looking at over the last year or so, looking at the possible risk areas. The legislation, as I'm probably going to mention again a little later, requires us to conduct a comprehensive assessment of reasonably foreseeable risks, both internal and external, which might give rise to non-compliance with the legislation. So the one thing is to identify the possible risk areas, and the other then is to build an action plan, and I'm delighted to say that significant progress has already been made at the university at the time I'm speaking, and there are some actions still to be completed, which represent the full commitment to achieving compliance with the legislation. So we'll spend some time looking at the impact areas, those things which affect all of us in the room and others are going to be watching the recording, and have a look at some of the actions we can take, both at a most senior level in terms of policy setting, at a managerial level in terms of helping to ensure compliance by other team members, and then operationally, the day-to-day things we as individuals can do to contribute to compliance on the part of the university. The third thing is very much aimed at some of the practical aspects of, so what do you want me to do to demonstrate that I'm helping to comply with the POPIA Act? And this is the part of the session where I think we're going to have the highest level of engagement, because I'll show you some scenarios, some examples of the sort of things that we will all do on a day-to-day basis, sometimes accidentally, sometimes inadvertently, and potentially cause problems for ourselves and for others in terms of demonstrating we're fully complying with the POPIA Act. If that's leaving you a little puzzled as to what those things might be, I know some of you have turned ahead and looked in the handouts, and for those of you who are following this presentation online, a full copy of the presentation slides, of course, is being made available, but we'll deal with that in more detail as we go. I've already mentioned that we're saving a Q&A session, or at least time for that, at the end of this session, but we'll also tackle some of those issues as we go along. So why should we treat this POPIA Act as important? And not least because the legislation gives room for the regulator to impose administrative fines, financial penalties. You might like to look at the person sitting next to you, or if you're viewing this in a post-live environment, others who are watching the presentation with you, to ask whether the person sitting next to you has a spare 10 million rand in their pocket to pay a fine should that be necessary. Well, you can relax. I think in most cases, there are one or two who are in the room or who are going to be watching the recording later who say, actually, that does apply to me. I'm in a senior enough position, executive position at the university, that I do need to think about whether or not we can afford to carry those sorts of penalties and what we need to do to avoid having to pay those penalties. So the penalty is payable by the institution, but as I'm going to, that doesn't let us as individuals off the hook entirely. In fact, there are areas where we need to pay great attention. So the potential exists for a penalty to be imposed, but that's not all. In the worst case scenario, the regulator, about whom I'll talk a little more later, has the power to impose a restriction on what we do in terms of processing of personal information. In the worst case scenario, should this involve, in the case of university, for example, some incorrect, illegal activity associated with processing student information, that could in effect mean our operations grind to a halt. Clearly, that's not going to be a healthy scenario. So the regulator, as I say, can not only take measures including financial penalties, but can actually issue instructions to say, sorry, you can't carry on the way you're going, and that could have a serious operational impact. Now, there's some really good news behind the scenes. It's not all about the big stick. There's some encouragement. And the encouragement is there in the legislation, and it's definitely part of the project we've had here over the last 12 months at the university to do a risk assessment to identify where are those potential areas where we can close any gaps identified to make sure that we are complying with the requirements of the legislation. So if we can demonstrate not only to the regulator but to other interested parties, there are many stakeholders that we'll deal with who are going to be curious about what we're doing as an institution, including, of course, the media and other authorities who are helping to fund the institution one way or the other, donors and so on. We want to be able to demonstrate good governance and that we're following the principle of conducting those risk assessments. Of course, with the risk assessment goes the appropriate remedial action plan, and that's the sort of thing that we're already underway with in terms of the POPI project here at University of Fort Hare. Along with that, and this is specified exactly like this in the legislation, is the expectation that if we have implemented appropriate policies and we have the procedures that back those up and we can demonstrate the practices that our people in the team are implementing on a day-to-day basis, then any potential penalty which might arise from a failure to comply with the Act will be very much less. In other words, if we are shown to be diligent, if we're trying to do the right thing, if we make a mistake, if something goes wrong, but we're working in the context of we really do care about this, then the regulator and no doubt other interested parties will look on us much more favorably. And I think in that context it's encouraging to know that as an institution you already have in place a number of those policies and procedures, and part, of course, of the objective of the session today, and those of you watching later on a recorded basis, is to help to fulfill that awareness of what the legislation is about and what role we can play in helping to make sure we comply with the legislation. Now, the question of, well, how does all this work not only here but in other countries around the world where privacy legislation has been in place for much longer? In fact, in the case of the United Kingdom, if you go back, they were one of the earliest countries to adopt privacy legislation back in the 1980s. We've got a wealth of international experience to draw on to say, so what are some of the other consequences other than a regulatory authority raising a fine or any interruption to our business activities? And the answer is sometimes it's down on a personal level to say that action is taken against individuals who are found to be wanting. Now, at an individual level, at an operational level, that might translate into use of some disciplinary procedure. It might involve warnings or remedial training, but at a more senior level, it tends to result in people losing their executive positions. There are a number of cases internationally. We haven't seen that to the same extent locally here in South Africa, but a number of international cases where the damage to the reputation to the institution when there has been a failure to comply with privacy legislation has led to senior people in the organization being asked to step aside. So some of the implications of what we're dealing with here can have a direct personal effect. I mentioned a moment or two ago that even though the fines which are raised by the regulator might not affect our own pocket, but the pocket of the institution, in this case the university, we are as individuals at risk of prosecution should we fail to collaborate with the work of the regulator. So if there is an incident and there is an investigation underway and we are asked to produce certain types of evidence or to attend investigation meetings and we fail to comply with those requests from the regulator, in fact, you could call them instructions from the regulator, then in our personal capacity, we can be subject to sanctions. So it's very important. It's not just a question of, well, you know, if there's a problem, the university has to worry about that. We have to think about that personally. I know that you'd say, well, it's obvious we're all committed to doing the right thing, but there is that ultimate sanction that if we are not collaborating as we should with the work of the regulator, then action can be taken against us on a personal basis. Clearly we want to avoid that situation arising, but I think it's important that we're aware of that. It's part of that creating awareness of the POPIA Act, one of the key reasons why we're here in the first place. So there's a pretty strong motivator as to why we need to think about the POPIA Act. One of the questions I've been asked over the last number of years is, well, where are we with this POPIA Act? There were some people out there who said, you know, it's never going to happen. South Africa's not ready for this. Way back in 2013, when the legislation first went on the statute book, people laughed and yawned and they said, yeah, it's going to be one of those things that never happens. Not true. It was always going to happen. And one of the reasons why we need to take this legislation seriously is because our trading partners, countries around the world, expect us to be trusted partners. And if we're not implementing this type of privacy legislation, then they'll take their trading opportunities with us elsewhere. One of the key challenges, as we know, that we have, and you're helping to address that challenge as an academic institution, is to develop knowledge, to develop skills, to create jobs. And our trading partners need to know that if center or have some outsourcing operations supported here in South Africa, that they must be able to allow us to manage their personal information on their behalf within the international context of effective protection of privacy. So it becomes very important for us to say, not only do we have legislation on the statute book, which we have as statement of intent, going back as far as 10 years ago now, back in 2013, but we can demonstrate the steps we've taken as a country since then. From the appointment of the regulator back in 2016, and the excellent groundwork the regulator did in building the team in the regulator's office, to issuing regulations to help to bring to life the legislation, to eventually, as we've seen now for the last couple of years, taking us to the point where the legislation has been, to use the technical term, fully commenced, it's fully in place and enforceable. At the time the legislation was drafted, it was always intended there would be a 12-month transition period. Well, that transition period has now closed. So we have a legal obligation as an institution to not only recognize, not only know that the Act exists, but to fully comply. And I think this is clear evidence, the group of people we have in the room here and the extent to which the recordings are going to be reused after today's event to understand how seriously we're taking the POPIA Act. So the time for talk is over, the time for action is now. So let's just have a little overview of what is this legislation all about. Some of you are probably young enough to remember very little about 1994, 1996. Some of us old enough to remember getting our first cell phone. You remember those days? 1994, and MTN and Vodacom, and you said, yeah, what's this all about? Do you remember borrowing a phone from somebody because you didn't have one in those days? And you wondered what would it take to own this fancy phone that couldn't do much more than make a call or maybe send and receive an SMS. How times have changed. Times have changed a lot. But right back then, when we had the new Constitution, back in 1996, a part of the Constitution, the Bill of Rights, made it very clear that we're all entitled to privacy in how we lead our lives. In fact, again, this is not a unique expectation for South African society. More broadly, on a global basis, the United Nations Universal Declaration of Human Rights back in 1948, that long ago, already recognized that as a global community, we have a right to privacy. The challenge, of course, in just having a constitution or a Bill of Rights is that it's not necessarily directly enforceable. It's more perhaps a spirit of commitment, a spirit of intent. So in many countries around the world, increasingly we're seeing that number grow. There's specific legislation which is enacted to do two things. The first thing we did, of course, in this country was not to legislate about how to enforce privacy, but we enforced or introduced legislation as to how we can ensure we provide access to information. So going back, and you'll see on the slide here, back to the year 2000, the Promotion of Access to Information Act was published and became enforceable about 18 months later. Here in South Africa, we joined the global community of countries that offer access to information. Sometimes it's called freedom of information. It's even called that legislation, Freedom of Information Act, in many countries. So from some 20 or so years ago, we've had a right as individuals to know what's going on. Importantly, not only in state institutions, as is the restriction in some countries, but in any activity in a private institution as well. And to know not just about our own personal information, but to know about the conduct of the activities in those institutions. So this is a right that we have as citizens to ask, to be demanding about understanding what's happening in society in general. So whereas University of Fort Hare and many other institutions have been getting ready for and implementing their compliance actions for the POPIA Act over the last few years, for very much longer have we been subject to the requirements of complying with the Promotion of Access to Information Act, known as PIA for short. That PIA legislation is now under the umbrella of the information regulator. It was previously the responsibility of the South African Human Rights Commission to provide the context and to ensure compliance with the PIA legislation. In the last year or two, that responsibility has moved across to the regulator. So now we very much have the balancing scales of justice. On the one hand, we're giving access to information. We, as citizens, we have a right to know what's going on in our own country. And on the other side, as individuals, we want to know that we have a right to privacy, and this POPIA Act, or POPIA, gives us now the means to ensure that we can address that right to privacy. So in the preamble to the legislation, both of those pieces of legislation are mentioned, and as we'll see, there are some common context, common terminology, such as information officer, which are used in both pieces of legislation. So the context for this is very much that we're part of a global community. We're trying to balance a right of access in terms of PIA with a right to privacy in terms of POPIA, and therefore we need to do a little bit of a deeper dive to understand the context for what we're doing in terms of complying. What is personal information? It's probably a good place to start the question that we may have. And if I look around the room, some of you are being very open about your personal information. You may be, as I see in one or two cases, wearing a name card which says, "This is who I am. This is who I work for." Some of us will guard our personal information more carefully because we don't want people to know too much about us, because then they're going to start sending us spam email or contacting us for all sorts of reasons that we don't want to get involved in that. So we'd rather keep that information private. But to be able to protect our personal information, we need to know what is that. If you wanted to get to know the person sitting next to you, and you're welcome to greet your neighbor. If you haven't already greeted your neighbor here this morning, I'll greet a neighbor or two. Good morning. Please greet your neighbor. Not too much greeting. So if we want to get to know somebody, there are some obvious things we're going to ask, isn't there? Hi, what's your name? Where do you stay? And if you want to take that relationship somewhat further, what's your phone number? Can I contact you via email? What we see on the slide here is a long list of various characteristics which make up personal information. Now, what's interesting is that the legislation deals not only with living individuals, but it also deals with what in the legislation is called a juristic entity. A juristic entity is one that has legal standing in its own right. In most cases, you'll say, oh, you mean a company. Yes, but it's much broader than that. It could be a charitable institution, not for profit. It could be one of the three spheres of government. It can be a wide range of legal bodies with one or two minor exceptions. For example, a trust. Whatever a trust does, it's not a juristic entity, even though it's a legal entity. But put that to one side, what we suddenly realize is that just holding the details in the procurement supply chain area for an organization, already the POPIA Act provides protection for the information about that organization, even if we don't have the details of any individual working in that organization on record. Not all personal information is equal. As I look around the room here, I can ask the question. I know there's one of my colleagues this morning who said to me, oh, I'm not feeling so well today. And I said, how are you? And I heard in conversation earlier, somebody said, oh, did you hear that so-and-so's gone off to hospital to have a minor operation? Now, some of these things, of course, we're going to talk about at a personal level because they're part of our natural day-to-day conversation making and a sense of concern about our fellow individuals. But the legislation recognizes that not all information is equal, and our sexuality, our medical history, our criminal convictions, our religious and political beliefs, even our biometric information on things like fingerprints and other ways of recognizing us, all of that is much more sensitive. And we are therefore expected to treat that information with a greater degree of respect. As we'll see, I've got a slide on that later, there are some additional restrictions that we have to enable us to respect that higher level of control, higher level of privacy, even though some of those items may be listed here. Now, as it says on the slide, including but not limited to, of course, there may be a wide range of different identifiers that we use. In this facility today, we're here in a wonderful building in East London. It's on the campus of the collaborative library between multiple academic institutions. So clearly we need to identify the students who use the library, which institution are they members of? Do they have a student number at that institution? Are they registered users of the library? And that gives rise to us creating unique numbers that are used for unique purposes, as well as having generally available numbers such as our South African ID number, passport number, and so on. So a wide range of different possibilities in terms of the personal information that we may have as individuals or may be created about us as individuals that form the basis of the activities to protect that personal information. This list is pretty comprehensive, but we also need to be aware that there may be additional things that are going to be subject to the unique requirements of the institution that may not be included on the list, but nonetheless will be considered personal information. The other important thing, we're getting our heads around some of the concepts as opposed to the context, and those of you who are following the slides will notice that in a very dynamic way, the paper copy you have in front of you, I've added one or two slides for clarity, but only a couple, and this is, I think, one of those, is that I realize that we need to be very clear about the roles we play in terms of the legislation. Hands up, let's see if we can get a show of hands. How many of you in the room consider yourselves data subjects, given the definition of data subject on the screen here? Are you alive this morning? You're a living individual. Okay, I mentioned the juristic entity. We'll leave that out of the picture. Do you have personal information? Is it collected from you by your employer, by your cell phone service provider, by your insurance company, financial institution, church, school, whatever? We all have lots of personal information that's collected about us. And it's important, therefore, to recognize that we are not only data subjects once, we are data subjects many times over, depending on the role that we're playing in society as a whole. Clearly, as an employee, I'm expecting to provide a certain amount of information to my employer to enable that employment relationship. And I'm going to provide different information at different times to different institutions. So I will be a data subject many times over. How many of you in the room have children in school today? You did the drop-off, yeah, maybe some of those who are watching this morning. You have an additional responsibility. As parent or legal guardian, you have the responsibility to decide what information about your child can be processed. Legislation places a restriction on who can make that decision. It has to be a parent or legal guardian up to the age of 18, when a child, in terms of, and they use the Children's Act definition, the child is then deemed to be an adult for POPIA Act purposes and can then make their own decision about what information is shared. Now, of course, we've seen a huge amount of abuse by some of the social media companies, social media platforms, and I'm delighted to say that we're also seeing significant fines being levied by some of the international regulators where those organizations are failing to put in place adequate controls, or where they claim to have those controls on investigation, they're proving to be ineffective. And that should give us some degree of comfort as parents, as guardians, that we can play that role on behalf of our children until they're deemed to be capable of making that decision themselves. So we're all data subjects. How many of us would consider ourselves to be a responsible party? Are you part of an organization? The very reason that you're in the room this morning is because you're part of the University of Fort Hare team, correct? Yes. Yeah? So we're part of an organization, and the legislation specifically says, or an individual in that organization who's helping to process the information. Just to get a feel, and again, it'll be interesting for those who are watching later to consider their role, how many of you in the room are what I would call academics? How many of you are academics? You're in some way responsible for delivering academic programs, developing, maybe you're doing research, yeah? How many of you are in the administrative area, providing administrative support around the university? Maybe some of you in the area of technical support, marketing, finance, a whole range of different areas of responsibility. In terms of the POPIA Act, and by the way, if I haven't mentioned your particular area in the room, you can buttonhole me later at the tea break and say, by the way, you forgot to mention me and my team. But the responsible party or individual working for the responsible party who's processing, and we can talk about what processing means, have a different role to play. The data subject is the one who provides the information, never hands over responsibility. It's always our personal information, but we are sharing that information with another party who have a duty of care. And the duty of care, in this case, is with the university and the team that make up the university, acting as the responsible party. And much of the POPIA Act focuses on the duties, the responsibilities, if you like, of the responsible party. So University of Fort Hare and every other institution you can think of that acquires personal information on a custodian basis, you still own the information, but any organization that asks you for your information and determines the purpose for which that information will be used, according to the Act, is deemed to be a responsible party. So you can be a one-person business, or you can be a school, or you can be a gym. You can engage in any number of different activities and ask people for access to or use of their personal information. That makes you a responsible party. So that's the second major role. I think we have our first question from the audience. Please remember just to mention your name and which part of the university you're from.
Thank you. Good morning again, colleagues. My name is Muriela Kinise, and I'm from finance.
From finance.
Budgeting, specifically. Just, I wanted you to elaborate on the process. You see that language says about whom PI is processed. What is actually processing? Can you elaborate on that? What activities are involved in that?
Yes, I think that's a really good question. And so just for clarity, you're asking what's involved in processing. And without trying to make it too technical, I would say it's the entire information life cycle. So where does the information come from when we acquire or collect the information? And remember, it's always the data subject who owns the information. So you could argue it's a copy of the information that we're acquiring, not the ownership. So it's from where does the information come from? And in particular in the POPIA Act, how do we get access to that in a legal way, which I'll talk about again in a few minutes. What do we do with it once we've got it? Where do we store it? How do we hold it? Who has access to it? What's the purposes we use it for? That's at the point where we have the information under our control. And further down the information life cycle, we may take that original information and update it or modify it in some way. Some of you have been around working for the university for some time. Anybody over 10 years? Let's not go further than that. But some of us will have been working for the university long enough that many aspects of our personal information will have changed. Maybe our next of kin, maybe our home address, contact details, cell phone numbers. So when we are processing information, we're going to at some stage be further updating the information. Eventually, at the end of the life cycle, we're going to in some way dispose of the information. Depending on the format that it's maintained in, we may use the term delete. We may use the term erase. We may use the term destroy. For an academic institution, of course, it may be never, in the sense that if we're going to hold an academic record, and I'm not sure, but I may be the oldest person in the room. Do you look older than me? That 20, 30, 40, 50, goodness knows, for research purposes, forever, somebody will ask, is that a legitimate academic qualification? And you need to be able to go back to the academic institution and say, please turn to your records and tell us whether or not this is a legitimate qualification. So in that sense, you might say some information never expires. But there is other rules which say, particularly in the POPIA Act, when the purpose which you gathered the information in the first place is no longer valid, then we must effectively destroy or otherwise disable the ability to use that information further. There's some technical terms like anonymization. So you remove the ability to identify an individual even if you keep some statistical measure about the information. So in brief, if that wasn't brief, the life cycle is from the beginning to the end. How do we get a hold of it? And at the end of the life cycle, when do we get rid of it? And we'll return to that theme a little later when we have a look at the rights of individuals and what they can ask us to do about personal information. I may be the only operator in the room. I haven't checked out all of your credentials. It may be that some of you are here with multiple hats on. Some of us are both employees of the institution, but also service providers. And the operator defined in the POPIA Act is a special type of service provider. The operator is one who provides a product or service, and in rendering that product or service, in some way processes personal information for which the responsible party has a duty of care or is responsible. Examples of that will be people who are in the IT space, accountants, lawyers, recruitment consultants, any organization who is going to assist us, the university, in the processing of that information, whether it be acquiring it, storing it, using it, disposing of it. The POPIA legislation, in common with other legislation around the world, talks to the operator as an organization that must offer that same level of protection or has to exercise the same duty of care as the responsible party. So the operator is going to process on our behalf. Now, the level at which they do that is going to be, it's mentioned in the POPIA Act, determined by either a mandate, but more often we will call that a contract. So the contract between us and our service providers should be very clear on what we are demanding of our service providers and how we want them to act in terms of the security levels that we expect that they will work with on our behalf to provide that level of protection. The operator also has some additional duties, such as notification to us, the university as the responsible party, in the case where there is a suspected or actual provable compromise in the security of the information. Compromise is a term that's used very broadly, but I think most of us would be more familiar with the term data breach. A data breach. Somehow somebody's got a hold of this information, or maybe in the case of ransomware, restricted our ability to get to or use the information. And it may be one of our service providers that's involved in that scenario, and the operator, the service provider, needs to fulfill its duties by notifying us what the scenario is, participating in an investigation, allowing us then as the responsible party to further notify the individuals, the data subjects who may be involved in, subject to that data breach, the regulatory authorities and other interested stakeholders. So the operator is the third main role, and that the final role that I went to mention here is the information regulator. I'll be returning to the regulator again a little later, but some of you may know that way back in 2016, and subject to and finally formally reappointed, Advocate Pansy Klakula, who used to be the head of the Independent Electoral Commission, was called upon by the President, then President, again now by the current President, to head up the information regulator team. I didn't do a final head count, but we are roughly 30-something people in the room here this morning, and that means that our team this morning in the room is as big as the regulator's team. In other words, it's a relatively small team. We are still in the process of building up that regulatory enforcement team. Go to more mature environment, such as the United Kingdom. In the United Kingdom's latest annual report, their regulator has over 750 people working in the regulatory authority. Now, admittedly, the UK, economically, the UK is 10 times larger than South Africa by whatever measure you want to mention, GDP typically. So you'd say, okay, so we could be a tenth of the size of the UK authority on a pro rata basis. Maybe, there's always no overhead to running that sort of organization. But that does at least suggest that, as has been suggested by our own regulator, there needs to be significant investment in growing our information regulator South Africa team for them to be fully capable of supporting compliance with the POPIA Act. And, of course, since the final legislation was passed, the PIA legislation, which I've mentioned briefly this morning. So these are the four role players, and we clearly in the room here are at least fulfilling the role of data subjects in our own right, and we're working on behalf of the responsible party. Some of us may be dealing directly with service providers who are operators, and selected members of the team will additionally be working with the regulator, potentially, and not only those who are live in the room here, but anybody watching this recording later, could be involved in an investigation should the regulator come in and ask questions about an incident or be performing some sort of audit. So although we won't all on a day-to-day basis be dealing with the regulator, that possibility is not to be excluded. Sorry, I just want to get ourselves back in business. So at a high level, I promised that this wouldn't be too much of a legal interpretation, but at a high level, let's have a look at what does the POPIA Act expect of us as an institution? What are we being asked to do to comply with the POPIA Act? And those requirements are laid out in a series of conditions for lawful processing. Somewhat confusingly, perhaps, they are not the only requirements of a responsible party. We'll come to the balance of those on another slide. But this and the next slide talk to the 8 conditions for lawful processing. And the first one of those, which is accountability, is not about having the Vice-Chancellor or my manager or somebody else having to worry about the POPIA Act. It's about all of us as members of the institution, accepting that we have a responsibility for ownership of what we do in relation to the POPIA Act, in relation to the processing of personal information. So however high or low you may be in terms of responsibility in the organization, we all personally need to accept ownership. Can you please shake hands with your neighbor who is equally accepting ownership? Are you accepting ownership? personal level of commitment. And then suddenly you're prompted to say, whoa, ownership of what? Ownership, what am I supposed to be doing? Ownership of the responsibility. The condition is called accountability, but accountability is not just about the high level, and you'll see it's later, the information officer, who is a uniquely named role player. It's about all of us being there representing the responsible party. So that's the first of the conditions. Second of those 8 conditions is a processing limitation, which says we must only be doing things which are recognized as being in the context reasonable and legal in terms of what we do with the information. And that comes back to what I mentioned earlier, is that fundamental right to privacy in the Constitution. So we must make sure that whatever we do does not infringe on that ultimate right to privacy. And that opens the door, as I mentioned earlier, to looking at special types of personal information where we have an increased expectation around that level of privacy. The third of the conditions talks to purpose. Why are we going to process that information? How many of you in the room here, when you joined University of Fort Hare, were asked for your shoe size? Anybody asked for their shoe size? What about your hat size? Anybody else? What's wrong with you guys? You seem reluctant. Nobody wants to tell me their shoe size or their hat size. And yet if I go and work for a mining company, or I work in other hazardous industries, the minimum requirement is there is a legal obligation for my employer to issue me with protective personal equipment. And we've seen in the era we've just left behind with the COVID pandemic, that personal protective equipment suddenly becomes a serious issue when there's something in the way of protecting ourselves as individuals. It becomes really important. Does that mask fit, for example? Now, what information we ask for and the purposes that we use it for must be specified at the time we're asking for the information. So we must have a particular purpose in mind. How many of you were asked for your driver's license details? Perhaps when you joined the institution, joined University of Fort Hare? Technically, of course, the university can ask for that if your job role is going to involve driving. It's legitimate that the university should ask for that, but not in general terms. The other thing that annoys me now is that when I'm asked to register, by the way, it didn't happen with University of Fort Hare. You're too forward-thinking for that. But I'm asked to register as a supplier by providing my fax number. And I talk to the organization that I'm going to be working with and say, sorry, why do you want my fax number? And they say, oh, you can ignore that. We don't use the fax number anymore. I said, well, don't ask for it. If you're not going to use it, don't ask for it. I actually had another institution the other day which said, we need to get confirmation of your bank details. Please provide a cancelled crossed check. And I phoned them and I said, sorry, but checks are no longer legal in this country. You know about that. They've been withdrawn. And they said, oh, we don't do that anymore. I said, well, don't ask for it if you don't do it. So we must have a specific purpose. And in fact, we may legitimately have multiple purposes. We ask for the information for an initial purpose. We may use it for other purposes later. This morning I arrived at the campus here in a hire car. And one of the things I noticed was that on the windshield of the hire car, it told me when the next service is due. And I was delighted to see that the next service is due a lot longer than it's going to take me to get back to the airport this evening. But when you do take a car in for a service, depending on where you take it, in this case it's a Toyota, it might have gone to a Toyota franchise dealer, they'll capture your details in the system, won't they? Please give me your contact information, etc. Next thing you know, they're trying to sell me a new Toyota or a used Toyota, or they're trying to sell me spare parts or come to our launch party. And I say, what right do they have to do that? I thought the POPIA Act was going to put an end to that sort of thing. Not true. What the POPIA Act does is actually enable some of the people we work with to use that information we gave them for further related purposes. So further processing says that an institution like University of Fort Hare is entitled to go to our student body and say, you signed up for this particular academic program, you may be interested to know that we've just launched an extension to that. Or you're on an undergraduate program, have you thought about doing honors? Have you thought about doing a master's? What about coming back and doing a doctoral program? The POPIA Act absolutely legitimizes that type of activity because you are using the information you have for further processing related to the initial objective. But if the university were to take a list of its student body with their personal cell phone numbers and pass that on to somebody else for activities not related to the work of the university, that would not be allowed. I think there may be a question from the back of the room. Good morning. Yeah, so the question that came from the back of the room was, how do we limit that further processing, or how do we use the further processing limitation to our advantage, to limit the activities of some of the people we deal with? The really good news is that the POPIA Act says that whenever an organization communicates with us, we have a right to ask that organization to stop any further communications. We have a right to do that. Now, the challenge is, of course, making sure that that right is enforceable. The ultimate sanction is that we can complain. There is a formal process where we can complain to the regulator to say, this institution is abusing my request not to contact me. And you may say, yeah, that'll never happen. Well, believe me, there are plenty of examples internationally where regulators are taking action against organizations who are abusing just that scenario. So where we say, please take me off your list, please don't call me on this, if that isn't happening the way it should, we have a right to complain. You could, of course, complain directly to the institution. That you may find as frustrating as trying to ask them in the first place. So the ultimate sanction is that you can go to the regulator and trust to the regulator's enforcement powers. Now, admittedly, that does take some time and effort. It's going to take us some effort to make that happen. But if as a community, as a group of people together, we say, now we understand our rights, I can do something about that, then we're going to become more powerful as a community as a whole. So further processing limitation was condition number 4. Condition number 5, information quality, says the following. In the past, your employer, your cell phone company, your bank, your church, your school, whichever institution, could determine their own level of quality of the information that they held about you, about your family, about your spouse, about your children. And you actually couldn't really do much about that except express some irritation. Why do they keep getting my cell phone number wrong? Why do they spell my name incorrectly? You could ask, but now you can enforce. Why? Because condition number 5, information quality, says there is a legal obligation that we, the university, or any other institution that shares the same responsibility of being a responsible party, must determine the quality standards that they're going to use and make sure that those quality standards are enforced. In practical terms, what does that mean? It means making sure on a periodic basis, and you can determine what that period is, that the information we hold about our students, about our staff, about our suppliers, about other stakeholders we deal with as an institution is correct, up-to-date, complete, whenever we think that's appropriate to do. How many of you recently have called a call center with your bank because you've got a query? Whenever I call my bank at the call center, apart from being put on hold, which we understand, eventually after I pressed a number of buttons to route my call correctly and validate who I am, sounds like somebody's bank is calling right now, is that whenever you call that type of institution, they're not only verifying for security purposes, they're also ensuring their records are up to date. So you don't have to wait until a year's passed before checking. You can have a routine which says every time we engage with that individual is a chance to make sure those records are up to date. But the POPIA Act does mean, the quality condition, does mean that we have to rethink what are our information quality standards, what is good enough, and how do we ensure that that information we hold is complete, is accurate, is up to date. Who here is from the HR team? Anybody in the room from HR? Couple of hands going up. Of course, you need to know who your staff are. Of course, you can ask them to let you know, but it's no longer good enough to say, well, you know, they didn't let me know, so no wonder the information went out of date. Now we need to have a business procedure which says, we have a policy which determines how often we're going to ensure that staff information is kept up to date. Typically, you'd say for staff, on an annual basis is a good time to do that. Some organizations that conduct, for example, annual performance reviews or have some other anniversary experience will take an opportunity to do that validation during that particular staff engagement. Maybe when it comes to students, an obvious time is when you're either doing an initial enrollment or a re-enrollment. Somebody's coming back for second or subsequent years of a multi-year engagement is a good time to validate we have that information. If you're dealing with suppliers, perhaps every time you receive an order which has to be fulfilled by a supplier, and you place an order with a supplier, and they then submit a request for payment, every time there's a request for payment, you do a validation. It's up to the university to determine what the frequency is that we use to establish that quality standard, but it's no longer a nice to have, it's a must have. Openness. I flew here to be with you in East London, and I distinctly remember being asked as I went through the Sapphire booking system online to click to say yes several times. And one of the things I was asked is to click to say, yes, I've read the privacy notice. Did I click? Of course I did. Otherwise I wouldn't get my boarding pass. Did I read the privacy notice? Probably not. I did, by the way, when I got my Avis hire car, ask the guy at the desk, I'm a naughty guy like that, I said to him, and tell me about the privacy terms. You know, the POPIA Act, I've just given you a whole lot of information. Oh, he said, it's all in the contract which we've emailed to you, which I thought was a very smooth response, but I've yet to receive the email with the contract, so we'll see what happens there. But suffice to say that when it comes to openness, we need to be open and honest about what we're planning on doing with the information. Now, the reason that we're holding this session this morning is so that those of you who are employees and therefore carry some of the responsibility also have rights. It's not only you are responsible for what happens with information, but you have a right to know what happens to your information. And so it's common practice now for institutions to develop multiple privacy notices, not just to have one on the website saying if you visit this website, this is what the cookies will do, you know, those cookie notices. Not only that, but also to have a dedicated privacy notice aimed at our staff, which tells our staff specifically what we're going to do with their personal information. Likewise, for other stakeholders we may engage with, for students, for suppliers, for the general public at large, etc. I think there was a question from the back of the room.
Good morning, I'm from the teaching minister. My question is, we sometimes conduct trainings online using our LMS at the initials or not their actual names, how would we mitigate that to ensure that they provide the correct names? That will, because those registers are then required by departments or even lecturers to ensure that these students have taken through the training that we provided.
Yeah, so the question is about the LMS, which is a learner management system. Yeah, and there are a variety of platforms available to do that. But the challenge is if people are logging in and just using initials and you can't identify exactly who they are, then you can't credit them with attendance or completion of whatever. I would suggest that in that case, you need to use what's called data validation, that they're only allowed to enter a name which is then validated against an existing data set. Now, of course, you need to be careful there that if I know that Joe Soap or Mickey Mouse is also enrolled, I'll make a nonsense of the system by using somebody else's name. So there has to be a degree of control which says you can verify whether it's using password or some other form of unique identifier. Now, in some cases, that may require you to make system changes. It may be that to implement those controls is not, if you like, for free. There may be some work that needs to be done. But I agree that if that identification is there to serve a purpose, then you shouldn't allow somebody to override that or to otherwise abuse the system.
Okay, just to add, we do have that in place. However, for our trainers, we create a separate link. They've got a platform on the LMS that they can authenticate themselves. But let's say I'm conducting a training for the Faculty of Education. I do not have access to that class. I have to create a link separately. So they need to enter as third parties into that training room, the online training room. Hence, they are able to put in names. However, that information is then later required by the department to say we need to stats of students that actually attended this training so that we understand why aren't they able to submit their portfolios on time, though training was provided for them.
Yeah, so the concern being raised, just for those of you who are listening to the recording, relates to some of the practical aspects of the unique identifiers used, and in particular if you're creating copy lists or you're creating unique scenarios which are not easily administered, that again may require some design changes to ensure that you have the same level of control when creating those unique lists. So there's no question that in some cases the quality aspects of information may require some additional work to be done to ensure you can enforce those quality standards. Thank you for the question. So openness, we were talking about the way in which we are open and honest about what we're doing with information that's being processed on behalf of the individual. Remember, it's always somebody else who owns the information. We're acting as the custodian. And depending on the role that that stakeholder plays, whether they're a student, whether they're a staff member, a supplier, member of the general public just visiting our website, we should be able to tell people about the way in which we plan to not only use the information, but all of the relevant related topics, such as what are we doing to protect the information, who are we likely to share the information with, and so on. The Protection of Personal Information Act, of course, has a pretty heavy emphasis on protection. And so understandably, condition number 7 deals with security safeguards. This part of the legislation says that we need to carry out a risk assessment, I think I mentioned this a little earlier, of all reasonably foreseeable internal and external risks and develop a response plan. Typically what this means is we need to look at physical security. To get into this building this morning, I was asked to provide certain information. I'm restricted to only visiting certain parts of the building, which is entirely reasonable given the context of what I'm here for, the purpose of my visit. So it's common for us to have physical security controls in place. It's also common for organizations to have digital security controls. If I glance around the room, I'm looking at probably 20 laptops, and everybody has at least one cell phone. Who's got 2 cell phones with them this morning? One for business, one for private, one for boyfriend, one for girlfriend, or whatever. But those digital devices, of course, need either protection at an individual level, or I use some shared resources like firewalls and other forms of security. Now, those security safeguards need to be not only assessed, need to be addressed, but we need on a regular basis to test whether those safeguards are still valid and to look for changes in terms of what the emerging threats are. So, lots of work to do. Technical and organizational measures. Technical measures might include some of the things I've just mentioned. You can add additional terms like encryption, password protection, and so on. And organizational measures can include having policies that people are required to follow and having awareness sessions such as we have here this morning. The last of the 8 conditions, and then I think we're on time to take our mid-morning break. The last of the 8 conditions covers data subject participation. Now we know what a data subject is. It's you, it's me, it's the people who own the data. We must be able to participate in what happens to that data. I mentioned PIA, the Promotion of Access to Information Act. That already gave us a right of access to information, but no more than that. We can ask, under PIA, we could ask an institution, what information do you hold about me, but we couldn't do more than that. Now the POPIA Act says we can go a lot further. We can object to what an organization does with our information. We can request that the information is deleted, erased, or some way destroyed. We can demand that the information is corrected where we deem it to be incorrect, not just something relatively low level like the spelling of our name, but if we have, for example, something about our profile which is either out of date or technically incorrect, we can insist that the organization updates our record to remove that. Now, there are some restrictions. We can't just demand out of hand, well, I used to work for you, but I don't now, and I want you to take me off your records. Because legislation says, no, for various purposes, we must retain a copy of that information. Where somebody who spoke earlier from finance, financial legislation, in terms of things like income tax and PAYE and a whole variety of financial reasons may determine we have to keep information for example, for 7 years. Other legislation, particularly in the HR area, may say 3 to 5 years, depending on the legislation. For those of us who I mentioned earlier might be working in hazardous industries, we have to keep that information, for example, in mining and asbestos, for up to 40 years, 40 years, after the individual has finished working for the company, after the last transaction on the file. That's what the legislation says. So even though the data subject can participate, we're not automatically going to carry out their request. We'll evaluate the request and then give a response which may indeed be complying with the request we've received. So we've been talking about the 8 conditions for lawful processing. Yes?
My colleague at the back has a question for you on the previous slide.
Yes? Your colleague, oh, there you are. I didn't see your hand. Maybe you want to give us your question. From the IT department, yep.
I just wanted to ask for that last part, data subject participation. On our side, we deal with clients. Maybe a client takes a laptop to us, then they ask the laptop to be promoted. And at a later stage, maybe after 2 months, they say that there's a certain document, an important document that was there on the machine. So how was we able to get this solution?
Sorry, I just need to clarify that with you. So you're from the IT department, you're dealing with your clients who are staff members, yeah? And what is it their complaint, their concern?
They ask that you format the machine.
Oh, reformat the machine.
Yes, then at a later stage, maybe after a month, they said that there was an important document that was in it.
There's an important document which has now disappeared.
Yes.
That's a very, very interesting point, because let me just resume my position for the camera. So it should be expected that any laptop, for example, that we're using, it could just as well apply to a cell phone or a tablet, but laptop, tower PC is a common device that's used to manage information. Ideally, we should have a policy which says no information is stored on the device, it's stored on a server, whether that server be on the premises or in the cloud, to avoid the sort of scenario where an important piece of information is held in only one place, because if we're not backing up every laptop, and quite frankly, very few organizations back up every laptop, they have a policy which says data is stored centrally. It may be that it's replicated onto a laptop, but the primary storage place is elsewhere, particularly, as I say, either an on-premise server or in the cloud server. It does, of course, suggest that if that's not happening, you may need to look at some of the written policies you have, some of the staff training, and then some of the procedural measures you have to make sure that the policy is being followed. I don't know if that gives you exactly the answer you're looking for, but that's certainly an approach I would recommend. Another question at the front.
In fact, to make it more interesting now, my name is Usana from the ICT department.
Yes.
And then now, let's say the person intentionally asking for the information to be deleted, knowing, or maybe the matter of fact, they are about to be investigated.
Yes, and if that is the case, if that can be proven that somebody's asking for information to be deleted, the POPIA Act says that that is a punishable offence, interfering with the work of the regulator, which may be, for example, investigating a particular scenario. It's equivalent to fraud, if you want to characterize it in some way. And one of the ways that we should be able to avoid that situation is by having appropriate policies in place. One of the challenges I think we have is that there are so many different places and different ways we can process information. We need to keep those policies up to date. How many WhatsApp groups do you belong to? And WhatsApp is not easy to integrate into the record-keeping history of an institution. Not only because of encryption in WhatsApp and so on, but it's a largely unregulated area. Now, please remember that the POPIA Act is to do with record keeping. If you have a notebook where you're keeping a note of something on a day-to-day basis, that may not be a formal record-keeping system. You create the record in the system, you can then scrap the notebook. It was only used for memo purposes. The danger is when people start using unauthorized record-keeping systems, instead of putting it into whatever the system is, they create their own little spreadsheet or some other tool which in effect is bypassing the correctly authorized system. Then we have to look again at policies and staff training and audits to make sure that we're capturing the information correctly. But these are some of the practical aspects that certainly need to be reviewed.
So policies limit the data subject participation.
So no, you can't issue a policy for enforcement against a data subject in most cases. If they are an employee, the employee is subject to the rules of the institution. But if they are an external data subject like a student, you can issue some guidelines, but the POPIA Act does not allow you to force a data subject to do something. The POPIA Act only allows enforcement for the institution. Are you with me? If I'm an individual, as I am, I can't be prosecuted under the POPIA Act in my private capacity. The law doesn't allow that. The law only allows an organization to be prosecuted for not legally processing my information. Now, part of the challenge may be to get your data subjects, your students, your staff, etc., to participate in the way you want, But that's part of the challenge, if you like, of doing business or being university. Students are known for being non-compliant, I think, aren't they, generally?
Because I was going to ask now, what if there's a data subject fraudulently given the university personal information that is not necessarily theirs? So now, for the university actually to be able to persecute, it then has to keep that information. Meaning, the information was given by the subject.
Yes.
The information actually from the beginning was incorrect.
Yep. So remember in fact, if I just go back one of the slides, one of the conditions is information quality. And you need to have the appropriate controls, checks, and policies in place. It's very common in the commercial marketplace, away from a university institution, that when you apply for a job in an institution, your details are validated with an organization that's engaged for that specific purpose, to check out whatever aspect is important for your future employer. It may be something to do with your criminal records. It may be your credit standing. Now, some of those things may be treated as special personal information, which I was going to come on to on the next slide, where your future employer cannot just go and run a criminal history check, for example. The POPIA Act says, no, that's sensitive information, and you must be given an opportunity to agree or disagree with that. Now, the consequences of not agreeing to a criminal records check may be your employer who says, if you're not going to allow us to conduct a check, we're not going to offer you a job. So you have to make those consequences clear. But that's one way in which you can overcome fraudulent information. And sadly, as we know, institutions like Fort Hare and other academic institutions must guard carefully the validity of the qualifications they're offering. It was mentioned in the introduction, I used to work for a couple of institutions that were doing MBA training. And when the Council for Higher Education went around and eliminated some of the institutions to which they said were not adequately complying, the volume of fraud for the better institutions went up. Because the people who were pretending to have an MBA now knew exactly which ones were the best ones to claim to have. Sounds crazy, but that's what happened. So you've got to be very careful with that quality aspect.
One last question, sorry. This is actually more a question directed to ICT as well, because you mentioned the storing of the information of the server.
Yes.
So I just wanted to find out that who now within, obviously, UFH has the access or has the right to request for deletion or removal of any info on the server, because there must be a protocol for that.
Yes, so the question, just to get clarity, is who has a right to implement, you mentioned on a server, but it could have been a paper record as well, but wherever the information is stored, who has a right to ask for that information to be removed or deleted? The answer is twofold. The legislation gives a right of a request to be submitted by the data subject, the person who the information is about, but you as an institution have a duty to evaluate whether or not that's a valid request. For example, I mentioned you may be required by law to retain the record for a certain period of time. You may also take the initiative as the institution, without consulting with the data subject, to say we're now implementing the rules which exist. It's not for you to determine when we delete the record, it's for us against our policies and other legislation. So I made that example of the person who's working in a hazardous industry. Somebody may say to you, you can delete my records now, I haven't worked for you for 10 years. And you say, no, the legislation says we must, for whatever reason, in this case, hazardous materials, must retain the record for much longer. Ladies and gentlemen, I'm going to suggest that we'll take one more question at this stage. I'm going to work through the material, and for the group who are in the room here, we can have an informal Q&A at the end of the session once the recording is done. Yes, may I help you?
Okay. So,
remember to introduce yourself for the benefit of the recording.
so the name is Vuyo from the Research and Innovation Unit. Just a quick one, like organizations like TI have a system where once you install something or you put in something, whether it's a document or what, you can't delete it for the period of 5 years, and they give you that laptop 5 years, and then after 5 years they take the laptop back. So would it require UFH to have a policy on such thing or what, in order for us to not lose such information?
Yeah, the simple answer to most of the questions around the POPIA Act is not what is it not, is what does the policy say? And if you have a rule set established, and we don't want to get too stuck with just turning to the rule book the whole time, you can use a policy as a set of guidelines, if you like, which are there for enforcement, and the detail is going to be in the procedural matters. So maybe some of you feel like this as I do, that your policy should be relatively short. It doesn't take very long to say we have a no smoking policy on campus, but the procedural matters as to how you enforce that may be somewhat more lengthy. So whatever you want to do, in particular in terms of information storage and eventual deletion, the policy can be very simple, which says we have a policy commitment to comply with the POPIA Act. See the procedural guide as to how we do that in practice. Thank you. So I mentioned that there are half a dozen other areas that we need to consider, the first one of which we've dealt with a couple of times already this morning, and that is special personal information. I mentioned that we need to have a lawful basis for processing personal information that may be via a contract, which is the appropriate lawful mechanism to use with staff, with students, with suppliers. We don't need to ask those people for their consent. You can't effectively work with staff if they say no, because your relationship is going to break down. It becomes part of a contract. Your staff must provide you with certain information, and that's covered under your contractual arrangement. Likewise with your students and with your suppliers. But the law says that when it comes to special personal information, a contract is not good enough. You must have explicit consent. And the individual must understand the consequences of if they withhold that consent, then the following is going to happen. For example, you won't offer a job to somebody who refuses to have their background checked, where you can demonstrate you have legitimate reasons for doing that. I've already mentioned children and the fact that they are protected up to the age of 18. There may be circumstances, very few, and not applying to the university that we identified during the project, where you need to apply to the regulator for prior authorization. Examples of that would be where you're sharing information between institutions in the way that the credit rating agencies do, and creating unique identifiers which are used between institutions. So those scenarios, prior authorization, really don't apply, and your legal team can look into that more if they need to. The information officer is, by default, the chief executive of an institution. In the case of your university and any other similar academic institution, it would be the vice chancellor. In a school, it would be the school principal. That senior executive is defined in the legislation as being the information officer automatically, by default. They don't have to choose. By taking on the job of being the senior executive, they are automatically the information officer. What they can do is delegate the day-to-day responsibility, but they can't delegate the accountability. So if the regulator is going to hold somebody ultimately accountable, it's still the chief executive, it's still the vice chancellor, even if other people have been asked to do the work on a day-to-day basis. So the information officer can be appointed within the institution, as can multiple, if you want to call them assistants, technically in the legislation, they're called deputy information officers. So those deputies will then assist the information officer in carrying out the work they need. And in conversation earlier today, I understand you have 18 or 20 of those already identified. I've worked with organizations that have only 1 or 2, or in some cases very many more, depending on the size and complexity of the organization. Your institution is not like some of those out there who will be sending out what many of us would regard as spam. The sort of communication which we never asked for is unwelcome, and we only wish that they would stop. Whether it's an SMS, sadly today, of course, with things like WhatsApp, you can be on a broadcast list in WhatsApp and not even realize that you're part of a mass communication. You might think it's coming to you as an individual, whereas in fact the person who set up the broadcast list is sending it out to hundreds of people at a time. So sometimes difficult to know whether you're on a list or not. Now clearly when you're receiving something that is deemed to be, as it is explained in the legislation, unsolicited, you didn't ask for it, and it's electronic, and it's directed at you, in other words, that excludes general advertising, then unsolicited direct marketing, there are rules around how an organization must proceed. Happily, your institution, University of Fort Hare, does not engage in such activities, and so you don't have to worry about that. But there are plenty of organizations out there that do have to pay attention to this and apply the rules when undertaking such activities. The last of the 6 major concerns for governing the behavior of the responsible party is what's called transborder information, or transborder flows of information. Interestingly, only outbound from South Africa. Once information comes in from elsewhere in the world, then the way it's processed is governed by our local legislation. So we don't worry where in the world the information comes from. If it's in South Africa, it's going to be managed according to our local rules. Our concern is when we use, in most cases, cloud services, or we use suppliers who are based overseas. And for the academics in the room, you may be thinking about collaborating with international academic institutions. Then you need to make sure that if that collaboration involves personal information, that we have the appropriate controls in place. Appropriate, they are listed, there are half a dozen, more or less, conditions that apply to those international transfers, including asking for consent, making sure that a country is on a list that's been approved by the regulator, having a contract, and so on. Again, when we were looking at the scope of work for the university, we identified those scenarios where this may apply and make sure we have the appropriate controls in place. So the bottom line is, as an institution, we have to pay attention to the 8 conditions for lawful processing and the 6 additional requirements. I've already mentioned PIA. Just for the record, I've got a couple of slides for you reminding you that the Promotion of Access to Information Act is that balancing activity along with protecting information under the POPIA Act or POPIA. We have to grant access under PIA. Most of us will not be receiving requests in line with the PIA Act for access to information on a day-to-day basis. Should you receive such a request, it has to be submitted in a particular form, on a particular form, then it's normal that you should route that to your legal office for them to deal with it. But it is important to know that such legislation exists, and why it's there is really to assist in transparency in the way society is run in general. It's not just about personal information. It's about any information to do with an organization. Now, I mentioned that we're going to have a look at some of the impacts and actions, and some of the questions that we've been dealing with this morning have already taken us down the road to say, which are the areas where the POPIA Act has an influence on what we do. Personally, what do we do on a day-to-day basis? Some of you have told me you're in finance, you're in IT, you're in marketing, you're in academic field. Each of us will have different scope of work to what we do on a day-to-day basis. Some of you are dealing more with your staff if you're in the HR area. Some of you are dealing more with suppliers if you're in the procurement area. Applies also to those who are watching this recording. This slide and the next give examples of some of the areas where personal information is processed. It's for each of us to recognize the importance of applying those 8 conditions when it comes to processing personal information for which we are responsible. Remember, as an individual, I'm working on behalf of the institution. I am, in effect, the responsible party. When I load somebody into the student management system, when I load somebody into the HR onboarding system, when I'm loading a update to a supplier profile in the procurement system, I am the responsible party. So I need to make sure that I understand what the policies are and what the procedures are that I need to follow in those areas. And these couple of slides give you some idea of the scope of impact that exists in terms of the work we do on a day-to-day basis. And if we were to reflect on this and start adding up the areas that some of us as individuals in the room are responsible for. In a large, diverse organization, it may be there are only 1 or 2 line items that you're responsible for. But in a small organization, and remember the POPIA Act applies right down to a family business or to a doctor's waiting room environment where you're taking a booking with the doctor's receptionist. In some cases, very small organizations, many of these things fall in the hands of just 1 or 2 individuals. So you may be a little more specialist in terms of seeing the scope of the impact. Now, whatever the scope of the impact is, we need to think about what action is required. I've mentioned earlier that the data subject is the individual who always owns their data. If we're going to process, we're going to acquire the data or personal information, store it, use it, update it, distribute it, copy it, print it, and eventually delete it or erase it. All of that is in our role as a custodian. And at a management level, as a custodian, somebody looking after that data on behalf of the data owner. There are a number of things we need to do to make sure that the work we do in whichever team we're in, whether it's in the academic field, some aspect of administration, various aspects of what we do as an academic institution, that we're ensuring that we are appropriately managing what I think we raised that question early on, whichever aspect of the information life cycle. So when we're talking about processing, it's where do we get the information from? How do we collect it? Are we doing that legally? Do we have a contract? If we don't have a contract, are we asking for permission? Are we asking for special permission when we're dealing with more sensitive information of the type that I've mentioned? Where are we storing the information? How many of us during COVID and the lockdowns were working away from our normal office? Working in a home environment presented many of us with new challenges in terms of storing particularly paper records and disposing of paper records. Don't have easy access to secure shredders, to storage bins that are later shredded and so on. We need to think about internal and external distribution. Sharing with an institution, sharing within the institution typically is not a problem unless we get to the point where it's a need to know. How many people would you expect to have access to the University of Fort Hare payroll file? Should we all be able to see the records in the payroll file? No. Interestingly, payroll is not, in terms of the POPIA Act, deemed to be sensitive information, even though we may think so. But it is sensitive in terms of who can get access to it. So we don't have to ask for special consent to process somebody's salary. That's part of the employment contract. But we do need to think about who should be able to get access. And there's typically 4 levels of access that we need to think about, and this applies to all of us in the work we do. The first level of access is public. I have here in the desk a prospectus. And this prospectus for the University of Fort Hare contains lots of information, including perhaps contact details and so on. None of this is in any way worthy of protection at a higher level because we want people to know this information. It's widely and readily available to anybody outside the institution. That's the lowest level of classification of security, public information. The sort of things we happily publish on our website, external website. The next level up is internal use only. Anybody in the university can gain access to that information, but it's not for general distribution outside. Typically, that example of that would be an internal telephone list. It may be it's an online list rather than a printed one, but you can look up who is that person, which department do they work in, what's their contact details, and depending on the sophistication of that, you may be able to see who else is in that department, who's the manager of the department, and so on. That's generally available information, but internal use only. The next level up in terms of security classification, and managers need to think about this in terms of the systems they use, is what we could call confidential information. The first example of which I gave you is the payroll system. only people who work in payroll should be able to get access to the payroll system, and of course the individuals should be able to get access to their own payroll record. But confidentiality says only people with a certain job role or job function are allowed to process that information. Now, payroll is one example. I wouldn't, for example, expect somebody in student affairs to be dealing with supplier information. I wouldn't expect somebody in the procurement or supply chain department to be dealing with information in HR. So there are going to be a variety of restrictions that we put in place based on what typically you can call the job role. The next higher level, remember we've got public, internal use, confidential. The next higher level is up to an institution to decide what term to use, but it could be called confidential restricted, highly confidential. If you work for the spies, you know those state security guys, well, they have a long list of classifications. But for most purposes, 4 levels of security say the highest level of security applied to information, it's restricted not only to job role, but it's restricted to seniority in the organization or the sensitivity surrounding the access to and use of the information. And so when we are managers and we think about that day-to-day access, we need to consider who needs to be able to do what in terms of the information. We know with our online, our digital systems today, it's easy enough to set up access rules. We can set up those access rules. What we need to do, of course, is maintain those. And sometimes when people move from department to department or change job roles, we forget, oh, I need to take that person off the access list. Typically, we're very good when somebody leaves the institution entirely. We're usually pretty good at removing those access rights. We need to make sure as managers we are following those rules. Managing deletion and destruction says we have to understand what is the policy and what are the external rules telling us, in particular those retention rules that I've mentioned. And then in general terms, managing overall compliance. I mentioned those 8 conditions and the 6 additional areas. So what sort of actions do we expect to take? Well, one of the basic ones is, of course, what we're doing here today and what people are going to be enjoying on the recording is to create awareness. Interestingly, the word training doesn't appear in the POPIA Act. Not just the word training, but education as well. But awareness is clearly positioned in the Act and in the duties, the guidelines of duties for the information officer and deputy information officers. So we need to create that not only at induction when somebody joins the institution as part of our onboarding activities, but on a reminder, on a periodic basis to maintain that awareness at top of mind. Of course, it's not productive to put people back into this sort of environment just to provide a reminder. There are lots of other ways that we can do that by having some sort of publicity campaign, having a theme like a privacy day or privacy week, running with posters in a physical display environment, sending out email reminders and so on. But nothing more effective, I think, than giving a person opportunity to either attend live this type of session or to watch a recording in terms of broadening that basic understanding. So induction and ongoing training. And then in terms of participation in making sure that things happen the way they should, I've got a little exercise that we'll do as we approach the end of the session this morning to give an example of the sort of things that we may not always get right, that we need to focus on, and to be aware that management are going to be taking action to ensure, from a good housekeeping perspective, that we are not just hygienically keeping the desk clean. It's not about having a tidy desk. It's about having a secure working environment. So in general terms, we talk about clean desk, but it may be it's to do with a shared area, print facilities, copy facilities, storage facilities, and so on, that they're appropriately managed. Our staff, we want to make sure that they're working appropriately. It's not to be excluded that there may eventually be some disciplinary process. If we have somebody who's failing to demonstrate that they've learned the lessons, we may need to implement up to potentially and including dismissal ultimate sanction. Unlikely, however it may seem, but not to be excluded, including going all the way to the CCMA, because we must demonstrate we have the teeth to enforce the policies that we have. One of the other things that I've mentioned is that it's very clear in the POPIA Act, it's no good doing an initial risk assessment. We must constantly evaluate for emerging risks. So over a period of time, we'll typically revisit, and in particular in the IT area, there's a whole series of emerging risks, and those we need to, as management, to take action to identify and to address. The really good news is that when it comes to what action is required and what the university has already done, is that over the course of the last year or so, again, I mentioned that the project was initiated back in, or the work started in June last year. Here we are a year later. There was a comprehensive review which has resulted in a risk assessment report being presented not only to the project team, several of whom are in the room here, but also back to other members of your executive, including the executive management team, so that they can be fully aware of what needs to be done to help the university to become fully compliant and to maintain a compliance posture. A wide range of actions, as I say, not only, but including working on risk assessments in a wide range of areas. As an institution, we must publish a Promotion of Access to Information Act manual, or PIA manual, and that's one of those items that's listed here. As previously, when looking at the impact areas, there are actually 2 slides worth of the actions required. Again, for those of you who are going to revisit some of the material who are online, you might like to consider the areas that apply most to you in the work you do on a day-to-day basis to assist in helping to make sure the university complies with the POPIA Act. All along the way, we need to bear in mind the role of the regulator. If you want to explore further, I give you the regulator's web address. There's a mine of information there, not only copies of the legislation, but all sorts of useful guidelines from the regulator, various forms to use so that we can, as individuals, as data subjects, exercise our rights, should we need to, in terms of requesting deletion, correction, objecting to processing, getting access to our information, and a regular update from time to time from the regulator about the work that they're doing. The bottom line is, as an institution, we need to make sure that we have an ongoing compliance plan that will demonstrate to all of our stakeholders, not only our staff, that we're serious about maintaining compliance with the POPIA Act. I think we have a question from the back of the room.
Yes, I'm concerned, most of the people here are also identified as people responsible for implementing the policy in the institution. There seems to be a lackluster reaction. The policy has been around, communicated from 2016 on. And I fear that there's a lackluster view in terms of the policy and how strictly the university might be taking this. Are we expected as the appointed individuals to take the disciplinary action that might be required, or is that responsibility of the office concerned, i.e. deputy register legal, or how do we take this seriously for lack of a better word?
So I think you've raised 2 points there. One, you mentioned lackluster. Are we really serious as an institution as a whole with POPI? I think this is an example of how serious the institution is. As I mentioned, we've recently had a briefing for the executive management team. We've already had 1 set of online training. This is the first time we've done this face-to-face. The suggestion is this is probably not going to be the last of the awareness sessions. In terms of making those disciplinary steps happen, it really comes down to what you've put into your policies and how you enforce any aspect of employee compliance with policies. So there may be some role for line management on a day-to-day basis. There may be some advice that needs to be given in terms of the involvement of the legal team, but it really comes down to following your HR guidance and HR practices in terms of escalations with disciplinary process. You shouldn't treat POPI compliance any differently to other aspects of compliance, whether it's dress code, health and safety, smoking, abuse in the workplace, and so on. So in the last little while, we're coming up towards the end of the workshop. I just want to give you some practical examples of how personally we can contribute to helping to make sure that the work we do on a day-to-day basis helps the university to maintain a compliance posture. There are a number of slides I'm going to show you. I won't embarrass you by asking whether these things have happened to you personally. I will fully admit that it's happened to me. Have you ever sent an email, in this case I'm using Zmail, but a message, have you ever sent something to somebody you realize you sent it to the wrong person? Yes. How often do we do that? I have 2 Andrews in my address book. The one Andrew said, "What was that thing you sent me?" And the other one said, "Where is that thing you promised me?" And only then did I realize, oops. You know how it does it with the autocomplete and you have a slip of the finger or whatever? Are you one of those people who makes pocket calls with your WhatsApp? You know, those, oh, I didn't really mean to call that person. If you're using the incorrect addressee, depending on the nature of the information you're sending, it may be that damage is being done, depending on what's contained there. So it's impossible to entirely eliminate this, but we do need to demonstrate that we're being vigilant, and as we are doing here, raise levels of awareness that these sort of situations can exist, and encourage people to be as careful as possible. One way to do that, of course, is to, on a regular basis, go through our contact list and make sure that we delete out of the contact list contacts who are no longer relevant, to avoid the situation that I've mentioned of having multiple addressees being confused. I've done this. Maybe you've done this as well. You've sent the email to the correct addressee, but unfortunately you sent the wrong attachment. I worked for 3 different business schools. I won't say which one, but one of those business schools, somebody in the MBA administration office sent out an invitation to the Christmas party with a reply slip. The only trouble was they sent the wrong attachment. They sent the salary list of all currently enrolled MBAs to every other MBA. I mean, I don't have to say anything else, do I? The danger of sending the incorrect attachment. Can you avoid that situation? Maybe, maybe not, but if that attachment had been password protected, that would have made a lot of sense. Maybe we'll get to the point where we never send attachments anymore because we send a link to where the information can be found on a secure resource, and that avoids sending the wrong attachment. So only people who have secure access to that resource can access the information. But at least we can start by putting password protection onto our attachments. There are many dangers involved in getting suspicious emails and links. One of the least exciting but most worrying things you can do when you wake up in the morning is check your spam folder. Not just your business email, but your personal email, and see how well you've been saved from clicking on that "you just won whatever it is they're claiming you've won," or take up this special offer. Most of which, of course, we know are not only fraudulent, but highly risky in terms of encouraging you to do something that much later or much sooner you'll regret. We do know, if the ICT people are to be believed, that these threats are most often involving what today is called ransomware. It's where hostile code, hostile programs are suddenly invoked, and we may not even be aware of it. Quite often, what happens in the background is only discovered many weeks or months later, when the damage which was intended to be done is suddenly made evident. And there are plenty of cases globally, some locally, where organizations have been thrown out completely. You're a port here in East London. You're one of the big ports around the country. And sadly, you may all be aware that Transnet lost the ability to operate any of its ports for a significant period when they were hit with an attack. In the UK, public hospitals were grossly inconvenienced. Thousands of patients' lives were put at risk when they were hit with a ransomware attack some time ago. So we must be very careful when we click on links or open emails from suspicious sources. It may be that you, like me, are working with spreadsheets on a daily basis. Anybody working with Excel or other tools on a daily basis, or once a year is enough? You only have to do it once. The challenge is that these types of information tools are risky if we don't pay attention. You know that you can hide a row in a worksheet, you can hide a column in a worksheet, you can even hide the whole worksheet. And if you don't remember what you've hidden and you send that worksheet or workbook to somebody else, they may unhide what you haven't remembered is there and you haven't protected by putting some proper encryption or password control in place. And then the damage can be done. How many ladies in this room would happily stand up right now and say, "I'm pregnant"? You might not do that in a mixed audience like this, because that's something that's really quite sensitive and personal, and you might like to think about your gender reveal party or whatever it is that's coming up. But when the British Pregnancy Advisory Service sent out information to all of the women who were enrolled in their services, you guessed it, they inadvertently shared medical information about everybody on the database with everybody else on the database. If you're busy on the internet right now, and a couple of you may be Googling to check what I say, go and look at the fine for the British Pregnancy Advisory Service. From memory, it was £200,000. That's roughly 4 million rand, all because somebody lost track of what information they were disclosing. You step away from your laptop because you have things to do. You've got to rush to the printer, you've got to go to the meeting, you've got an urgent bathroom break. And what do? We trust that the IT people have set up a security control so when my screen time's out, everything will be okay. Well, maybe that's not good enough, because we complained we need 2 or 3 minutes before it locks automatically. A lot of damage can be done in that time. So what do? Well, one example is maybe we do that. Did I close my laptop lid? No. Oh, by the way, don't you like the picture of my little grandson there? Say, "Go James!" Go James! He's just had his half birthday. You can see maybe under the clock there it says 6. Just 2 weeks ago he was 6 months old. How's that? But I invoked my lock screen by just hitting the Windows and L button on my keyboard. I didn't close the session. I didn't close the lid. I didn't shut anything down. But I did invoke the lock screen so that whether I'm stepping away, and it's going to come up in a moment, so whether I'm stepping away briefly to go to the printer or I'm going to the coffee area or whatever, I can make sure that my computer locks instantly and it's going to be securely retrieved. Just waiting for this to change. Yeah, here we go. It's not only email, thank you guys, it's not only emails we receive that may be hazardous. There are lots of websites that we may visit that are infected. Be careful when you're on, you don't necessarily know that it's an infected website, and you don't know that it's a hazardous link. Whenever you're going to click on something which says, click here, link, or when you mouse over it shows up as a link, be particularly careful as to where you're heading. And if in any doubt, call the IT guys for advice. I'm sure you don't do this. You'd never do this, would you? Put something up with a password written on it, nice and handy so you can remember. Of course you wouldn't do that, but you might write it down in the back of your diary or on the blotter on your desktop, or put it in the right-hand drawer of your desk, or some other similar activity. Of course we need to protect passwords. And look at your neighbor. Would you ever share your password with your neighbor? We hope not. Confidential documents. I went to see a client the other day, and they left me unattended in one of their conference rooms, and I picked up a document rather like the register we have here, which is an internal register. It only has your name, department, and signature. Nothing particularly sensitive about that because it's an internal document. The one I picked up in their conference room had people's personal email addresses and personal cell phone numbers from attendees from many other organizations that they'd hosted a meeting. And I said, wow, that's a clear breach. And the reason for my visit was to brief their executive management about information security. Some of you may recognize that my name is connected to this picture. What is my name? Tobin. Another way of saying that is to bin. So the question is, to bin or not to bin? That's the question. Some of you may recognize that was Shakespeare or something. But have you eliminated desk-side waste bins? Can I walk around your campus here or at Alice and see nobody has waste bins anymore? Some organizations have done that, because then you'll never put the wrong stuff in the waste bin. We need to think carefully about printing. If we are going to print, we need to think carefully about disposal, whether it be into a shared confidential waste bin or directly into a shredder. We need to have appropriate behavior. Just because you have security on your cell phone doesn't mean that you've set up your message viewing correctly. Some people are quite happy to have messages pop up on top of their lock interface. That may compromise personal information. Physical security is as much part of protecting information as digital security, so we need to make sure we have key registers. We take seriously when keys are lost or mislaid or potentially stolen. We need to secure physical assets. In this case, I give you, oh, sorry, it's a little bit behind. There's my key. There's the next one. We need to think about this example where that laptop bag may include not only digital, but paper records. Who knows what's inside here? Maybe some removable media. So be careful with the physical assets as well. Even though we are using paper less and less, some of us may still have this scenario where we have desk-side or office-based local storage. We need to think carefully about what we put into that storage and how we best use security mechanisms, whether it be our office door, cupboard locks, or whatever, to restrict access. Please don't use these things, even though I spoke to one of my colleagues at the back this morning asking whether he had a stick, and he said to me, oh yes, but I use Apple, implying it was going to be 100% protected. I didn't want to go down that road, but it's particularly dangerous that these devices, even if we think they're adequately protected, may encourage us to use USB or removable media of various types without fully checking that they really are secure. Just because the access card doesn't tell you which institution it's for or which door it will open doesn't mean it's okay if we lose it. We need to make sure we have appropriate security controls in place for physical as well as digital security. I can't even remember all the reasons why my paper doesn't come out of the printer when I expect it. It's because I'm at the back of a long queue, because the toner's run out, because the paper's run out, because the power's out, because there's a fault on the printer, because I didn't actually send it to that printer, I sent it somewhere else. All those things happen. And that puts at risk personal information. Be very careful about using shared devices like printers, copiers, and so on. So here's the real test as we come into the last few minutes that we set aside for the workshop. Some of you sitting next to a neighbor, some of you watching this recording may be sitting with a colleague. See if you can identify the more than 10 violations that are going to be shown on the next screen. And for the purposes of this exercise, you don't have the solution screen, which I'll show you afterwards. We'll see there are definitely more than 10 examples. So here we go. In this picture, if you've been listening to what I've been saying over the last few minutes, you'll definitely be able to identify at least 10 violations of protection of personal information. Please work with your neighbour and see what you can find. I see most of us have a neighbour. There are a couple of people who seem not to have neighbours. Okay, thank you. Thanks, everybody. Are you ready? Yes. Let's give it a go. How many of these did you get? So if we start... Okay, thank you. Thanks, team. Thank you. Your enthusiasm is appreciated. Let's have a look from the bottom left. I'm going to use some numbers and let's see what you think. 19, what's in the waste bin? 6, what's in the laptop bag? Go across. Number 12, somebody could steal the entire tower machine or use removable media. 17, what are those papers sticking out? 19, or 18, sorry, why aren't we using the keys? Go to top left. Number 5, what's on that notice board? Number 20, what's in open filing that should be locked away? Number 2, what's that little Rolodex, little address book thing, device that I have? Number 11, why isn't the computer locked? Number 13, what's on the WhatsApp paper? Number 7, what's that bunch of keys doing there? Number 14, what's coming out of the printer? Number 10, what about that cell phone left abandoned? Number 8, what about the notes that are made in the workbook? Number 9, what about the digital recorder, the voice recorder? Just go up to number 16. What's written on the board? Maybe a password. And number 15, rather strangely, what can somebody see while they're walking past, or hands they can put in to steal devices when they're passing by? Ladies and gentlemen, thank you so much. We set out just a little under 3 hours ago to really try and do 3 things. Number 1, educate. Create awareness about the POPIA Act. Number 2, to stimulate some discussion. And number 3, to motivate you to take the POPIA Act seriously. I really hope that we've achieved the objectives. Only you can judge that. I know you'll be asked to give some feedback at a later stage. I'd like to just once again thank the project team that have got us to this point, and I'd like to thank all of you for your time, and those of you who are going to be watching online for taking time out. It is an important topic. I know you have the best interest, University of Fort Hare, at your heart. We are going to switch off the recording now. There's chance for any informal final Q&A. So once again, thank you very much, and good luck with your compliance efforts. Thank you.